This is part 3 of criminal procedures, looking at exception to the warrant requirement and plain view doctrine. Where there is a reasonable expectation of privacy, such as in your home, for the plain view doctrine to apply, the officer must be lawfully on the premises, and the incriminating character of the evidence must be immediately apparent. Where the evidence is in public view, there's no privacy expectation. Exception to the warrant requirement and voluntary consent to a search. When looking at whether consent exists, you have to look at the totality of the circumstances, or behavior of the officer, whether there's a threat of harm, compulsion, or the officer erroneously stating they have a valid warrant. Another exception to the warrant requirement and third-party consent to a search. A third party may consent to search of a property that they own or that they occupy. May not consent to property not owned or occupied. Where it is jointly owned and or occupied, so your roommate, the defendant must be absent for third-party consent to be valid. So you and your roommate cannot both be present. They ask you for consent, you say no. They then cannot ask your roommate for consent. The roommate says yes, and then they can validly search. They cannot do that. Looking at wiretapping. Wiretapping must be limited in time. They must have probable cause a specific crime has and or is about to occur. Wiretap must name persons, describe with particularity conversations to be overheard, and provide provisions for termination of the wiretap. Looking at standing, this is where you have to show a reasonable expectation of privacy. This is testimony you must provide to show the reasonable expectation of privacy, where you have to testify for standing. The evidence provided in standing testimony may not be evidence at trial. Looking at the exclusionary rule, and this is different than the exclusionary rule under the rules of evidence, which is Rule 403. Here, the exclusionary rule is the rule that evidence obtained in violation of Fourth Amendment rights cannot be admitted as evidence. That's from Weeks, which applies to the federal court. This all developed in the early 1900s. Weeks, which applies to the federal court, applies to the state courts via map. Also, you have the fruit of the poisonous tree, which is derivative evidence discovered as a result of the primary search, may also be excluded. There are exceptions to the exclusionary rule, such as where the evidence may have been inevitably discovered through lawful means. They have an independent source for the evidence. But the most broad one is where the officer acts in good faith on a facially valid warrant. This is kind of some of the progeny. Aftermap involves the officer acting in good faith on a facially valid warrant. This is generally employed to overcome failures where there might be a Fourth Amendment violation. An example may be where the warrant is put out that maybe misspells the suspect's name or superimposes the address. The police go to that address, which is the wrong address, search the place, find evidence of drugs, arrest the person, charge the person. Person may be convicted because the police did act in good faith on a facially valid warrant. And that is from Leon. Of course, I've stated before, the Fifth Amendment applies to the states through the 14th Amendment. Self-incrimination in the context of civil and or criminal proceedings. You cannot be compelled to be a witness against yourself. This does not protect non-testimonial evidence such as urine, blood, and or breath, or records required by law such as tax returns. Now, you may protect records where an act of turning over the records constitutes incriminating testimony. You may protect them under the Fifth. Invoking the Fifth, in the context of a defendant, you do not take the stand. And invoke the Fifth, don't take the stand. If you take the stand as a defendant, you waive your Fifth Amendment protection. In the context of a witness can be compelled to take the stand. The witness must invoke the Fifth Amendment protection in response to a question. Witness waives their Fifth Amendment protection if the question is answered, but it is only waived for that question, because the nature of the Fifth Amendment protection does not go to the proceeding, it goes to the nature of the question. Looking at Miranda, Miranda is required for a custodial interrogation where incriminating statements are inadmissible unless the suspect is informed of their Miranda rights. Custodial interrogation, it's custodial if a reasonable person would believe they are not free to leave. It's interrogation if expressed questions and words and or actions likely to elicit incriminating response are made. Miranda must be given before the interrogation and or after long gaps in an interrogation. If you interrogate somebody on Tuesday and they leave, they come back on Wednesday, you may have to re-Mirandize them. Suspect must make an unambiguous request for an attorney and invoke a right to remain silent. This right may be knowingly and or voluntarily waived where the suspect makes an uncoerced statement. The content of Miranda is you have the right to remain silent. Any statement may be used against you in court. You have a right to consult an attorney, have an attorney present during interrogation, or attorney will be appointed for you if you can't afford one. Using statements made in violation of Miranda at trial. Now, interestingly, there is no violation of Miranda until the wrongly obtained statements are used at trial. Now, even statements made in violation of Miranda, they may still be used to impeach the witness and only to undermine the truth and or veracity of the witness's statements. Confession, fruit of a tainted confession. This is non-Mirandized confession. Physical evidence is admissible if the confession is not coerced. So you have a confession, you obtain physical evidence from that confession. That physical evidence is admissible if the confession is not coerced. Again, it's voluntarily made. The Fifth Amendment use in proceedings. You may invoke the Fifth Amendment and refuse to testify at trial, in depositions, administrative proceedings. Again, the privilege of the Fifth Amendment goes to the nature of the question, not the proceeding. Any question that may incriminate you in present and or future criminal proceedings, you may invoke the Fifth Amendment. The prosecutor may not comment on the defendant's exercise of the privilege. Looking at immunity, you can generally compel a witness to testify by granting them immunity. So if they want to invoke their fifth, you can grant them immunity and compel them to testify regardless of the Fifth Amendment, and regardless that they have invoked the Fifth Amendment. You have testimonial. However, testimony obtained through immunity may not be used against a witness. You have transactional and derivative use immunity. Transactional immunity is full immunity. Use and derivative use immunity is that you cannot use that testimony against that witness. And again, immunity is all that is required to compel testimony where the witness is invoked Fifth Amendment protections. And that completes Part 3 of Criminal Procedures.